Good morning. Welcome. Welcome to our Facebook Live event, and hello to all the TikTok universe. For those of you who are on TikTok, if you want to see these events and see their schedule in advance, go ahead and head over to our Facebook group, which is called Decode Your Divorce Arizona Support Group. And today's topic is going to be a great one. We're going to be talking about gathering evidence and getting exhibits into court. This series has been about how to tell your story, present your case, talk to a judge, and today is going to be crucial. I just want to welcome Julie Lebenz, my co-host, and Brianna DeBoer. Thank you both for being here.
Hey, Billy, great to be here again.
Yeah, so Julie, do you want to give a quick overview of your background before we get started?
Sure. So I'm a lawyer. I'm licensed to practice in Arizona. I've been a trial lawyer since 2006. I've handled all sorts of different types of cases in court, but for the last, 5+ years, I've been more focused just on family law, even though family law has been a part of my practice since 2009. And yeah, there's a lot of hearings potentially in family court, especially if you're not engaging in negotiations in a really strong way. So there's a lot of cases that can go to court. I know that a lot of people out there are facing false accusations and things like that, where, negotiations have completely broken down and they're having to go to the judge. And what is the evidence that can be presented to help them overcome, a lot of false accusations and things like that, especially when, like time with your kids is on the line and things that are really important. So that's a little bit about me. I also just wanted to take a moment to let everybody know that, at least from my perspective, like the energies lately have been really intense. I'm up in Sedona, so, I'm into that kind of stuff, but it's a full moon tonight. And I got to tell you, I feel like I just can't catch a break these days. And I'm wondering, feel free to add in the chat if you're feeling the same. And, at times it's like going into this victimhood, like, oh, why is this happening to me? And kind of feeling bad for myself. And then there's also like this fear factor, like what's next? Oh my gosh, like, oh my, what? Oh my God, and getting really scared about what's next. And what I'm finding is that I'm needing to just stay really present and listen to what messages are coming through these problems that are happening, instead of going into the why me or the what's next, really connecting with, okay, this is actually a problem that needs some attention. And what can I start doing to address it instead of going into guilt, blame, shame, fear? But I got to tell you, and I don't know if others are feeling this, but it's been super intense. I'm hoping things start to shift. I'm like not even making any plans at this point because everything is just not working out for me right now. So I just had a feeling that maybe some of you out there going through family law problems are maybe feeling the same thing. This is a full moon in Gemini, which does relate to children. So maybe some really serious issues related to your kids are coming up. I know I've had some of that personally, and it's been very painful. So we're with you, we feel you, and you'll get through it. And if you can connect to this moment, maybe that can be helpful as well. So, Billy, any thoughts?
Well, I appreciate you sharing that. I can tell you we've gotten tremendous feedback about these lives being very, very helpful to people. We're able to go much more in depth in this type of conversation than we can in a quick video or in a comment or a discussion on Facebook. So it really allows us to talk about the nuance, and the law is really all about the nuance. So that's what we're going to do today. We've got our topic, which is gathering evidence and presenting evidence in court. And then, as always, we'll have time for Q&A. So go ahead and send over your questions, and we will do our best to answer them. But first, we're going to spend, about 25 to 30 minutes talking about evidence. You mentioned that there's a lot of hearings. And I think one of the things that people lose sight of is that this is litigation And in litigation, it
Mhm.
means you can't just show up and tell the judge your story and call it good. You have an obligation to gather evidence that supports your point. Now, last time we talked about how to come up with your story, how to tell that story. But once you decide what story you want to tell, how do you determine what evidence you need or where to get it?
So first, I just want to give some quick little disclaimers, and then I'll jump into that answer. But by being a part of this live, or asking questions, even, Billy and I don't become your lawyer. Also, we're only providing legal information. We can't provide legal advice in this type of setting. It's not possible. So this is just information. We're not telling you what to do. You have to make your own decisions. And we're licensed in Arizona. So this is about Arizona law. Evidence. One thing to be really cognizant of is thinking about things from the judge's perspective.
Mm-hmm.
And if the judge is receiving evidence where dad is saying one thing and mom is saying another, you've got kind of, think of the scales of justice. You've got equal scales. And
Right.
so you're looking to bring in evidence to help tip those scales in your favor. And that evidence that can tip the scales in your favor can sometimes be very simple evidence
Mm-hmm.
to gather. It could be a secondary witness
Mm-hmm.
who's corroborating your side of the story. And then boom, there's more evidence on your side than the other. And you become more credible because of that secondary, corroborating witness. Or it could be something more complex depending on the case. But it's something to be cognizant of, that you've got a judge who doesn't know you, who wasn't there for maybe some event that is disputed about what the exact facts are. So how can you show that your facts are true? Also, let's talk about what is evidence, because I get a lot of confusion from clients thinking that they can't, like, their words are not evidence.
Mm-hmm.
But testimony, sworn under oath testimony, is evidence. Okay,
Mm-hmm.
you can have documents to support it. You could have audio recordings or video recordings as additional evidence to support your testimony, but your testimony is evidence. So
Mm-hmm.
keep that in mind. It's not just like, oh, whatever, I just have some stuff to say and it's not that big of a deal. No, it is a big of a deal. It is a big deal. That's one of the things that the judge can base his or her findings on.
Mm-hmm.
So understanding that, and then also understanding this concept of speculation.
Mm-hmm.
When you're testifying, you want to be in a position where you're testifying about events that happened, that you're not speculating about what may or may not have happened. So even if you know that if you ask your co-parent, to help or to take some additional parenting time or to just exercise their parenting time that's been court ordered, that they're going to refuse or not communicate, you still need to take the steps to ask. Because if you're going to go to court and be like, oh, but they always refuse, they're going to come in and testify, oh, but if he or she would have asked me, I would have taken the time. And then your point isn't made, even though you're like, oh, but they're lying. The evidence before the judge is you never asked, and they said if you had asked, they would have taken it. So now your point isn't proven. So you've got to think about that. Don't go in with these preconceived notions. You've got a third party person, the judge, who you need to show how this person is, not just talk about it in general terms based on what happened 5 years ago.
Mm-hmm. One of the most important things to determine is which facts are undisputed. The two of you agree on them. They're uncontested. And there's a whole section in your pretrial statement where you put and you write down the uncontested facts. And that should be a large section. But determining what do we agree on and what facts don't we agree on is pretty critical to determining what evidence you need. Because if you know that you're going to talk about what happened on XYZ date in different ways, you're going to say X, he's going to say Y or whatnot, then you have your scales of justice right here, and you need more evidence. What could that be? It could be text messages. It could be emails. It could be another witness. It could be an admission or testimony in a deposition. There's a lot of ways to come up with evidence. So, and one of the things that you wrote down here that we're going to talk about is demonstrative exhibits. Can you explain what a demonstrative exhibit is?
Right. So it sounds really confusing, the word demonstrative, like a big legal term, but it's actually quite simple. This is an exhibit that you create to illustrate a point you're trying to make. So for example, you can take your proposed parenting plan. And instead of taking 20 minutes to testify about every single pickup drop off change and everything that happens with the holidays, you can have it on 1 to 3 pieces of paper, depending on how detailed your plan is, and have that as one of your exhibits. And then boom, you could just testify about the nuances, maybe the really big points that are in dispute about the parenting plan. You could just focus on those. And then the judge has a document that the judge can take and look at and doesn't have to remember or be furiously writing or typing what your proposed plan is. So some of it can be very simple, taking your parenting plan or your child support worksheet and showing where your numbers are coming from. Or for example, if you have what's called a community lien interest, you live during your marriage in your husband or wife's house and they owned it separately. It was not bought during the marriage. They owned it prior. It's their separate property. But you were together for 10, you were married for 10 years and you paid down the mortgage during that time and made improvements. You can make a claim called a community lien claim, and there's a calculation called the draw host calculation. And so rather than testifying to all these different pieces, you can have a 1-page summary of your draw host calculation to go to the judge. What about a child support arrears argument? Summarize what's owed. So this is what we're saying, make it really simple. You can take points that could take a long time to explain and put them into a 1 to 2-page document.
Yeah, it's essentially a summary, and there are some rules. So I just want to go back to Julie's example about when you said, in her example, you said, I know that she's not going to take parenting time because she's always refused in the past. One wonderful demonstrative exhibit, and Julie said, you need to ask. One really beautiful demonstrative exhibit would be a chart that has the date you asked and the times that mom didn't show up for parenting time. Now, if you want to get that admitted, there are special rules. If it's a demonstrative exhibit, it means it's something that you've created to demonstrate or summarize the evidence that you're offering. That means you must make available to the court, along with that demonstrative exhibit, every single correspondence that you have cited in your chart. So you've got a chart that says these are all the dates mom didn't show up, and then you've got every email or every text message that corresponds with the chart. Then you would testify to that.
And think about how much better that is for the judge. Instead of handing the judge a stack of 50 pages of correspondence and being like, okay, judge, you review this, you've got a nice summary for the judge to look at, and the judge can flip back and confirm the summary is accurate by looking at these supporting documents. But otherwise, the judge is having to make their own summary, because you can't go through 50 text messages and remember every single point. You've got to make a summary of it. So making this easier for your judge, and Billy's exactly right, you need to have the supporting documentation. So if you're making a child support argument about what you did and didn't receive from the other side, do the summary, but attach the bank statements,
right?
Or attach the checks, or, however the payments were made. Have a summary with what the point you're trying to make. And that's,
if opposing party tries to get in a demonstrative exhibit without making every single document available, that's a great time for you to object, because that's not okay. Now, and you want to make it very easy for the judge. So in your table, I would suggest you then cite to the page number on the exhibit that has the evidence you want. You want to make this so crystal clear for the judge. And you know what this does? When you are so prepared and you present your evidence in a way that is so easy for them to consume, do you know what you get? The benefit of the doubt. We've tipped the scale a little, because you seem so prepared. You have everything so well laid out that the judge is automatically going to be more inclined to trust that than somebody who's all over the place and doesn't have any exhibits and says, well, I've got it, it's just not here. Like, you just can't be that person.
At the same time, sometimes it can be really frustrating because you can go in completely prepared and the unprepared person sometimes quote unquote wins. And
Mm,
I've had that happen throughout my career, either a self-represented party or an attorney that just has not put in the time and effort that I did. And yet
mhm.
they end up winning. And it's just, sometimes your facts just aren't that great, despite all of the
Right.
preparation. So do you still do the preparation? Yes. But unfortunately, the outcome is out of everybody's hands. It's up to a judge at that point, and you don't know what the judge is going to do. And sometimes that can be a really tough pill to swallow.
Absolutely. Let's go back to our example. Let's say you have a chart that says that mom didn't show up, you know, 8 out of the 10 last time. But mom shows up and she says, but I've moved. I've changed my life. I have a new job now. I have reliable transportation. I can get there. The judge may very well say, yes, I believe you that mom didn't show up 8 out of 10 times. And I'm still not going to change parenting time because mom testified that she moved and she got a new car. And we still believe that it's in the best interest of the children to continue to have the parenting time, that even though mom didn't exercise it, that is an absolute
Yeah,
possibility.
definitely.
Um, your evidence must be disclosed to the other side before, in order for it to be admissible. Now, can you explain what disclosed and admissible means?
So disclosure is something that happens outside the courtroom, outside the clerk's office. You don't file your disclosure with the court. This is information and evidence that is exchanged between the two sides to give each side notice of what's coming. Now, it didn't always work this way. There used to be like
Mhm.
surprise evidence where you could just bring it the day of trial. And eventually the courts were like, this just is not efficient.
Mhm.
And they changed everything and they made it so now, think of playing poker. Like, you got to show your hand. You can't
Mhm.
hide it and then show it at trial. You have to put your cards on the table, generally at least 30 days before trial. There's various disclosure deadlines depending on what type of case you have, but you need to get that out there. And it doesn't go to the judge, but it goes to the other side. And it needs to be all of the documents you intend to use, documents, videos, audios, any sort of exhibits you plan to use, plus a list of your witnesses and
Mhm.
their contact information and a brief summary of what they're going to talk about.
Mhm.
That's going to be required. If you don't do that, you face the problem of that evidence or that witness being rejected at the time of your hearing because, for non-disclosure reasons.
Mm-hmm. And Brianna, I just wanted to say out loud so we don't forget, we have very recently put together a chart, a really great chart that explains what must be disclosed and when under Rule 49. Let's make sure to put that on the Facebook page so that anybody can download it. And it makes it very clear what you must disclose, because there are things that you must disclose regardless of whether or not you want to use it as evidence. And you have to disclose anything that you might want to use as evidence.
Mm-hmm. So
So,
you got to get your disclosure done. And then also be aware that the court's going to have their own rules for submitting exhibits to the court. And the judges are so serious about these rules. So you really need to know what your rules are and abide by them. Be that talking to the judicial assistant or talking to the clerk's office or getting information online from the court's website. But you need to comply with these exhibit deadlines. And in preparing your exhibits to go to the court, if you have an exhibit that's more than one page, staple it together. All right. You don't want to have you or your witness up there with 20 pages loose. That's one exhibit. It's too difficult, and it's going to eat up a ton of your time while you're trying to manage 20 loose pieces of paper. Add page numbers on the bottom right corner. If you've got a 20-page exhibit and the information that's important is on page 9,
mhm,
you should have it numbered, and then the part you want to focus on, that should be highlighted as well.
mhm,
Um, again, whether it's you testifying or you're presenting this document to one of your witnesses, they're going to struggle figuring out where page 9 is and finding the exact paragraph you're focusing on unless it's made really simple for them. Because remember, you or your witness are already nervous up there testifying. Everybody's looking at you while you're talking. It's the judge. It's a serious courtroom situation. make it simple, and it takes a lot of pre-planning. So I would start, especially for somebody who has no experience submitting exhibits to the court, I would start at least 30 days before the exhibit deadline, getting all my copies made. You got to give a copy of your exhibits to the other side, making sure everything's numbered, stapled, and highlighted, and is all pursuant to what the judge wants. And then I probably, just if this was my first time, I would look to submit my exhibits a day or two before the actual deadline. Because what if you go to submit them and the clerk is like, oh, wait, you did this wrong and you need to correct 10 things. If you're on your day of the deadline, yikes. But if you've got 2 more days because you did it early that you can correct it and get it in, great. Also, sometimes counting the days is confusing because the court sometimes counts weekends and holidays and other times doesn't. And so that's another thing too, by going a few days early, if there's any question about the final deadline because of a holiday or weekend or something weird, you can just take out any sort of potential controversy by filing a day or two early.
Yeah, those are great points. It is not easy to represent yourself. It is not. There's a lot to know. And because there's a lot at stake, that is why we are giving such detailed information. Now, many of you know that we are launching a live course and community that is called Win Without Law School, dedicated to people representing themselves. We will be able to go over this in detail. People will be able to take the courses, watch the recorded courses, and really get assistance if you're representing yourself. But we're not gatekeeping information here. We're giving you a lot of it for free now. So one of your points also is that you must actually gather evidence, not just seek to present speculative evidence. Tell me what you mean by that.
Right. So we've talked about this a little bit. You just can't say, well, judge, they always don't take their parenting time, or they've never paid child support, or, they don't call at the time that they're supposed to, when the kid's with me or something like that. Like, you need to actually gather the evidence, show that they didn't call or make that request. You can't just say, oh, well, this is how they've always acted, so judge, find that they would have done the same thing.
Got it.
That's not going to work. But one other point that I do want to touch upon is how to get an exhibit admitted into evidence, because it's actually really simple once you understand it. But when you don't understand it, it's super confusing and it's weird. It's like a weird process. I remember even learning it for the first time and being like, oh, this is awkward. And it's kind of like each little piece you're doing. So you're kind of making little progress and then finally move to admit. So there's a lot to it.
It's still awkward, even for me now. But before we talk about how to actually introduce your exhibit, one thing that I think a lot of people don't understand is that, okay, so we talked about how you submit your exhibits to the clerk before trial. Now, many people think the judge should have reviewed those exhibits before you present your evidence. They do not. Like, public service announcement, and they're not supposed to. They're not allowed to. The judge is not allowed to look at your exhibits prior to trial. If you want your judge to look at any of the evidence that you have given to the clerk that you want to present, you have to go through the process that Julie is going to tell you about now. That is different from the pretrial statement. The court should have read the pretrial statement. Now, your pretrial statement we've talked about in other lives, and you can go back and watch those if you have questions on it. But so everybody knows the judge has not looked at a shred of evidence. So now here we are, we're in court. How do you get the judge to actually look at the evidence?
It's a really good point, Billy. People think that they file their exhibits with the court and the judge looks at them, but the judge can't. And so instead there's going to be a stack or a box that's organized with files with the various exhibits in the courtroom near the clerk. And every document that is in that pile or in that box that you want the judge to see, you're going to need to present as an exhibit through one of your witnesses. And of course, you can be a witness. You likely will be a witness. So you could be your own witness. And then if you have any other witnesses, you need to get these exhibits admitted through your witnesses. Now, prior to the trial, you can reach out to the other side and see if you can stipulate to the admission of any exhibits. That's the easiest way to go. You got to do that step, because if you can mutually say, yep, I'll agree all yours get admitted, I agree all mine, of course, if that's in the best interest of your case, that's super simple. Then just everything comes in. You don't have to worry about doing this song and dance about getting stuff admitted. But for any or all of the exhibits that have not been stipulated as being automatically admitted, you'll need to, first of all, present the exhibit to the witness, and that you can present it to yourself if you're testifying. So, okay, if you're presenting, I'm handing the witness exhibit 1. Or if you're testifying, judge, I'm going to talk about exhibit 1 now. If you're asking the question, first of all, you need to identify it, the witness does. What is exhibit 1? And the witness shouldn't start reading from the document necessarily, but they need to give a short little summary of what it is. So it's a warranty deed to the marital home, or this is my proposed parenting plan, or this is the child support worksheet I would like the court to adopt. You know, something, just go ahead.
This may be easier as an example. So let's pretend I'm the witness. Show people what you have to do as either the attorney or the self-representing party to get the document admitted, and understand the judge cannot look at the document unless it's admitted. So I'm the witness.
Okay, I'm handing you what's been marked as exhibit 1.
Thank you.
Can you please explain what exhibit 1 is?
Exhibit 1 is my affidavit of financial information.
Is this a fair and accurate copy of your AFI?
Yes, it is. I completed the AFI on this date. I did it myself. I can attest to its truthfulness.
Move to admit exhibit 1.
Now the judge can look at the AFI, and the AFI might have been a bad example because those have to be filed. So the judge actually would have already looked at that. But let's say she had handed me an email. I would have to say, yes, this is an email that I wrote to my ex about blah, 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 blah.
But Billy, let's talk about how it usually goes. So what is exhibit 1? It's an email. Okay, what's the date that it was sent? And then this should be highlighted. Okay, so the witness can look exactly to the date. Oh, this was sent on November 30th, 2022. Oh, who was the sender? Billy Tarasio. Who is the recipient? Julie Lebenz. What was the title of the email? Stop harassing me, or whatever. Is this a fair and accurate copy of the November 30th, 2022 email that you received from Billy Tarasio? Yes. Move to admit.
Right. So when you get this document, you have to describe it, why it's accurate, and then the other side has the opportunity to object to the admission of that exhibit. And there's a multitude of reasons that you could object. If you're both representing yourselves, then this might not come up. And we'll have to do a different live on the rules of evidence surrounding that. But that's the process for getting documents admitted. And if you don't admit a document that you've already submitted to the clerk, it goes back to you and you take it home. The judge never looks at it.
So it's really important to, like, if you've narrowed down your exhibits to 5 and you know you want to get those 5 in, you need a plan for that. If you've kind of, you know, you've done 20 exhibits and some of them are there just in case something comes up, but you don't really need them, then you should be highlighting, like, of those 20, what are the ones you definitely want to get in, and make sure that you do. A couple of other things just about preparing and organizing. So you should be making a trial notebook for yourself. I like a 3-ring binder. And in that is a copy of your exhibits and the other side's exhibits, because remember, the exhibits you filed with the court are going to be going to the witness. And if you're wanting to read something off of that exhibit after it's been admitted, you're not going to go to the witness and grab it back from them and read it, or have, or maybe, you know, you just need to know where to look on the page to direct the witness to read a particular paragraph. Like, you should have a copy in front of you too. And also you can make what's called a bench book for the judge. So you can also provide the judge with a copy of all of your exhibits in a notebook, you know, ordered and everything, for the judge to be looking at while the testimony is being given. I've had a couple of judges that don't want bench books, but that's been very rare. Most of them want a bench book because they want to be able to look at the document that's being testified about in real time.
Yeah, and some judges in Maricopa County are just using the electronic copy and they don't watch bench books, but each judge, at least in Maricopa County, has a page on the courthouse website that tells you what their rules are. And it's very helpful to do things the way that they want you to do them. We do have a lot of questions to get to. Anything else
Great.
you want to cover on evidence?
That wraps it up. Evidence. Okay. It's more complicated than it looks, and really it's about a lot of advanced planning.
Yes, absolutely. And practicing. I think you cannot underestimate the importance of practicing. You have a very limited time. You have exhibits. You have to say, move to admit, which I forget. And I have been a lawyer for 17 years. And somebody will start testifying about a document and I'll be like, oh, did I move to admit that exhibit? So it happens. You're going to want to practice. All right, first question today. In what instances can a party be awarded legal fees? We've been in a custody battle since May of 2021, and Dad and his attorney have dragged it out, and it's resulted in costing me thousands in legal fees.
Judges hate legal fees disputes. They deal with them, but keep that in mind. Like, just coming in and complaining that they've dragged things out is not going to be the most compelling to the judge. I'm not saying it's not an argument to be made, but it's not your one and only argument. So first of all, there's a statute for legal fees. It's 25-324, and it applies in divorce cases and custody cases. And it looks at two factors. It asks the judge to look at, number one, what are the financial resources of each party? And that's going to be really relying on that document, the affidavit of financial information that each party is supposed to file. That's one of the biggest pieces of evidence the judge is going to look at to determine financial resources. But there's obviously resources outside of just the AFI. So there's more evidence that can be presented on that issue. And the second part of 25-324 is reasonableness of positions taken throughout the case. Now, this is something where the party's definition of reasonableness and the judge's is usually completely different. From the judge's perspective and the case law that is controlling the judge's perspective, the courts are supposed to look at not just taking a position that's opposite of the other side. Like, just because you disagree, that doesn't mean that you're unreasonable. But if your disagreement is contrary to law, or if you're refusing to follow the rules of procedure, like you aren't doing disclosure, you're just like, nope, not going to give you anything, then the courts are more apt to award legal fees. But just because you think the other side's been stupid or drug this out, like, the court's going to be like, well, welcome to litigation.
Right. Yeah, it's a hard thing. In what instances can they be awarded legal fees? There's two reasons. Either a disparity of income, one person makes a lot more money than the other, and in that case, you might be on the hook for paying their attorney's fees, regardless of reasonableness or portion of their legal fees, or unreasonableness. And like Julie said, that what percentage of your cases would you say a judge orders somebody to pay legal fees based on unreasonableness?
It's a low percentage, like very low. But it's an egregious situation is when I do get an award of attorney's fees. And it's usually for a discovery violation. They're just not producing documents that are really relevant to a disputed issue. I'm trying to think of like a legal issue where there's a dispute that's completely unreasonable. That one's tough, because you could think, oh, they're asking for sole legal decision making and there's no basis for it and that's unreasonable. And the judge may be like, oh, you guys just disagree. It's okay that they asked for that. That's not unreasonable.
Or a judge might find it unreasonable.
Yeah, it just depends.
Yeah, I would say in my cases, maybe 30% of the time, attorney's fees are awarded. So I think it's more common in Maricopa County than it sounds like it is in Yavapai County or Coconino, where you practice.
Yeah, Yavapai mostly.
Yavapai.
The other thing to consider with legal fees is if you are awarded fees, you get a judgment. Okay, you get a piece of paper that you then have to convert into money. The court and the judge doesn't like stick their hand in the other side's pocket or bank account and hand you the money. Instead, they just give you a judgment and you have to collect on the judgment. And depending on the situation, collecting on the judgment may be extremely difficult to impossible. So it's like you can get this beautiful attorney's fees award, but depending on the situation, the financial situation on the other side, you may or may not be able to actually collect.
The next question we've got today is, me and my ex have 50-50 custody. I just got a modification for child support for almost $1,800 a month. My ex does not see or speak to our children at all. So I'm really not trying to change the parenting time or any of that because I don't think it would be worth it. Not a can of worms that I'm trying to open, but I need my kids' passports. I have sent emails and text messages for about a month. And my question is, can I ask the court for permission to obtain passports for my children? And if so, what paperwork do I file?
Have you dealt with this issue before?
Definitely.
Yeah. What are your thoughts on this?
So if you have joint legal decision making, you can't go get a passport for your children without the other parent's signature. If you have sole legal decision making, then you are allowed to get a passport without the signature of the other parent. You can file in court to specifically request that parents cooperate to get passports. I like to do this in a divorce if kids don't already have passports. I want to get in front of this issue. But if we are post-divorce, then, and you've got a trip coming up, you're going to have to file. You're going to have to file and request the court have this person sign those paperwork. Then you need to determine, is this person likely to show up or not? If they are likely to show up, I want the paperwork with me in court at that moment so that you can get the signature. And then some judges, because otherwise what you're going to do, if they don't show up, you're going to get an order that says, perhaps, in this case, dad has to sign the passport paperwork. That is basically as useful as the judgment that Julie just talked about. It's a piece of paper. It's not going to make it happen. So you really got to determine what's going on. And I take these cases situation by situation, sometimes a demand letter from a lawyer or a call from a lawyer, and then sending a mobile notary along with the paperwork is the best way to go. It's going to be cheaper and faster than filing something in court. So it's really a practical problem that we have to come up with a solution for. And it might be a legal solution, but it might just be a different type of solution.
Yeah. And, when you talked about getting in front of it with the divorce decree, if you've got a situation where there is language in the divorce decree requiring both parents to cooperate and sign off for passports, then you're looking at an enforcement action. Right. You're looking at enforcing that term. On the other side, if you don't have that term in your decree, then you're looking at asking the court to order the other side based on joint legal decision-making, what's best for the kids. But the other side could come in with some objections to the travel for some reason. And, who knows if the judge will do it. But I think Billy's point is also sound. If you're all at a hearing and there's a piece of paper that you can get signed right there, because there's notaries at the court, if it needs a notarization, you can potentially do that right then and there. But it's a tough one, especially if you've got another parent who is claiming you're going to kidnap the kids and not return them abroad and stuff like that. A judge may be like, well, I don't want anything bad to happen. So I'll just, you just don't know what's going to happen, especially if you have somebody making a lot of allegations against you.
Absolutely. The next question we've got is, I've not yet filed, so I'm gathering information on how I can be efficient and prepared for the attorney that I'd like to hire. Good for you. So smart. What is the best way to organize evidence in a clear, concise manner to present to your attorney? Or better yet, some possible background information on how an attorney uses and decides which evidence to use once it's received from the client. That would be helpful in my understanding of how to organize the evidence and what is factually important versus the moments I don't like, but they're not relevant. Well, first of all, thank you for the very intelligent conversation and question. Obviously, you are really getting your ducks in a row. Julie, what do you think of that question?
So yeah, it's a great question. And as far as getting organized, I would say start with a timeline. I find this to be so helpful. And it's really like, okay, January 2007, married, February 2010, first child born, it just giving this chronological history of course, those important events of marriage and kids being born, but also other things that are related to issues in your case. So this is when we bought our house. This is, what happened with, anything that is important in the case, to start doing a timeline that can be really helpful. And then you can sit down with the attorney, talk about the timeline, identify the issues in your case, and then start making lists of, what is the evidence that's going to be helpful to prove this? And is it something that's already been created, that already exists? Or is it something that we want to start creating going forward? So in, for example, like a parenting time, a case with a parenting time dispute, you may want to start keeping a journal. What's happening with parenting time on a week in, week out basis, because by the time you see the judge, maybe 6 months have passed and now you have a record of what happened, instead of just being like, well, we did this, I think, and that, and it's like you've got a really clear record. And it also builds your credibility, I think, in the eyes of the judge. It's not just, this is what I remember. No, here's my written record of what happened that I kept in real time, which I think can help with the credibility.
Yeah. Absolutely. And one of the tools we created for this exact purpose is a divorce planner that you can download from the Facebook group. It has a place for you to fill out items of personal property that you want, items that you want to go to him, your pre-divorce budget, your post-divorce budget, a place where you can list your assets, your kids' names and birthdays. This is a journal for you. It also has a calendar in it where you can write down any notes about what happened in any exchanges. This is a tool for you to stay organized, to stay focused, to plan, but also an excellent way to communicate information to your attorney in an organized fashion. So definitely check that out. Lots more questions to get to. Father's out of state. We're not married, but he's on the birth certificate. What can I do for a parenting plan? My child's 17 months old and I'd like to keep him here in Arizona. I'd like to keep him here in Arizona. It's too much for him. He keeps bothering me to continue to rotate, which is impossible for me. What rights do I have? Okay, so dad is out of state. The child is 17 months old and dad wants to rotate the child's residence from Arizona to out of state at 17 months. And she wants to know what rights she has.
Well, do you have an open case going? Are you looking to file? Right now, your mom and you're unmarried. He's on the birth certificate. But, if there's no court orders in place, there's nothing that's forcing you to agree or to give him certain amount of time. And, this type of question would be really good for a consultation, because there's so many nuances here. Like, is this a situation where you should immediately go and file and try to get a court order? Or is it like, you know what, maybe it'd be best to kind of wait a little bit, because I'd like to go when the child's a little older or when a certain situation has unfolded. Like, there's a lot of just nuances about your situation that would play into this question of whether or not to seek to establish decision-making, parenting time, and child support at this juncture, if that's best for you or not. But ultimately, that's the way to resolve this issue. If you guys can't reach a parenting plan that's agreeable, is to have the judge decide. Now, oftentimes what I find is that the the parent that doesn't have the kid the majority of the time is maybe making proposals for equal time, not that they really want the equal time, but in an effort to reduce or minimize child support. And so that may be his motivation here. He may be asking for this kind of crazy parenting plan for a 17-month-old where you have, a long distance situation because he's concerned about what child support may be. So one potential technique here is to make a settlement offer that is your parenting plan, but that agrees to reduce child support or make it a number that is workable for him so that you have a guaranteed outcome. And then his needs are met with the child support. On the flip side, if you're like, I need the full child support, I think I'm entitled to this plan, you can take it to the judge. But, I don't know what the ultimate decision will be of the judge. I've seen a judge where they decide, oh, even though it's a lot of travel for the little one, before the kid gets into school, this is the time where they could spend more time with the long distance parent. So they actually order a pretty crazy travel schedule for a little one, being like, oh, well, this is going to change when they get into school. So let's do this now to give them time with that other parent. And then I've had other judges who've been like, no, that's totally crazy. The kid's going to be with the one parent the majority of the time, and the out-of-state parent can come and visit the child while they're this little and spend parenting time in their community. You just don't know how a judge is going to rule.
Yes, yes. And these situations, here's what you need to know. You need to know that right now, as an unmarried parent, you have de facto sole legal decision-making. Okay? You don't have to do anything, but there are consequences to whatever choices you make. And the other thing that you really should keep in mind is the UCCJEA, which is which state will have jurisdiction over the case. You said you would love to keep him here in Arizona. Then because you said that, it is very important that your 17-month-old lives primarily in Arizona. So when you're deciding, when you two are working out how much time that your little one is going to spend outside of Arizona, it's just something to keep in mind. But I will agree with Julie that this is the type of situation where a consultation would be important because there's a lot of nuance. Next question, can you do an example of how to submit evidence without witnesses?
Oh, okay. So you're always going to have a witness to get the evidence in through. I'm guessing, I don't know if you're interpreting this question differently, but you may be your only witness. So maybe that's, thinking, oh, well, I don't have a witness, not thinking that you are your own witness. And so you should, in fact, in most situations, take the stand and testify, and can have documents admitted into evidence while you're testifying using the process we talked about earlier.
Yes.
Any
So
thoughts on that?
you testify, you say, here's exhibit 1, this is my blah, 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 I move to admit it. So you just do it, you just monologue what Julie and I did. There's another question here that came up on TikTok that I want to address because it really bothers me. And it says, is it illegal for mom's boyfriend to hit my son as punishment?
Yeah, it is. I mean, nobody.
I agree. Nobody has the, yeah. Sorry, keep going.
Yeah, it's the proving it is what can be frustrating and challenging, because if the other side's denying it and the only evidence is what the child is saying, unless there's a physical, evidence, there's a bruise, there's a red mark, there's something to corroborate what this child is saying, then it can be really tough to prove. And this is another thing where you're going to want to gather this evidence. If the child comes home with a bruise that they didn't have before, or, inflammation, a red mark, some evidence of physical abuse, you need to take a picture, a video, you need to gather this evidence so that you can show what you saw.
Yeah. If it were me, I would come out swinging. I would write my co-parent and let them know, hey, my child told me that your boyfriend hit them. I am a mandatory reporter. As parents, we are mandatory reporters as parents. And then at that point, I would either report it or I would tell the other parent, I would ask them, did this happen? Are you allowing this? I want to make sure that I have the information I need before I determine what to do next. If it were me, I would flag for that co-parent that it will not be tolerated. And you have options as a parent. You can call DCS, and you have to if you think your child is being abused as a mandatory reporter. You could also secure an order of protection if you had enough evidence. You could file something in family court. And even if I agree with Julie, the proving it is hard, but it is not hard to make it very clear immediately that you're going to do whatever it takes to protect your child. And I do think that we have a lot of influence over our child's behavior with how we signal we're going to respond to certain things. So if your co-parent is, at all reasonable and rational and doesn't want to get her children taken away, she's going to talk to her boyfriend, hopefully, and set some boundaries. And if she can't, you need to know that right now and get your kid out of a very dangerous situation. So I hope that that helps.
And Billy, I think that you made a really good point, which is to reach out to the other side and open up a dialogue, because, especially if it's a young kid, you don't always know if exactly if what's being said is exactly accurate.
Right.
And so that's where I would start, is reaching out to the co-parent and saying, hey, Johnny came home after co-parenting and he had this bruise and he's telling me this story and I'm really upset. What happened here?
Yes. Yes. You know what you're doing there? You're creating evidence. You're being a responsible parent. Like, you're doing a lot of things by asking questions. Even if you're not going to get an answer, even if you think you're going to get a bad answer, even if you think that they're going to be mad at you or mad at the child, you have to document this because you need the evidence.
And that's such a good point. Even if they're going to hang up the phone on you or deny it, you need that. This goes into our point about speculation. You need to gather the evidence. Look, I called them to talk about this serious concern and they hung up on me.
Right.
Like, that's good evidence versus, oh, I knew they just would have hung up on me. Like, that's not convincing.
Yes. Or if you get an email back that says, this is none of your business, that's an admission. Like, you want that. You want that response. So, I hope this is helpful and good luck. I can tell you, my heart goes out to you because one time my kids had a nanny at their dad's house that was hitting them. And we've never allowed that. Like, that's just not okay. And, but all of my kids were telling me the same story. This lady, like, she washed out my kid's mouth with soap. And we were in the middle of a divorce. And I went to my ex. I was like, what in the world? And he kind of blew me off and I lost it. I did. So I feel you, but I also, there is a lot we can do to influence our children's environment. And we have kind of a responsibility to influence our child's environment, whether they're at school or the other parent's house. If we think there might be something wrong, we don't lose that obligation just because we don't live with our children full time.
Yeah. And one final point on that issue is seeking to get the child into counseling, because the counselor is a mandatory reporter. Obviously, if the kid is suffering physical abuse, that's trauma, the kid should get some counseling for that. But then sometimes that can be the best outcome, because if it's you coming in and making the accusation, then it's this whole he said, she said, and that, we have this history of disputes. But if it's a mandatory reporter counselor coming in and saying, oh my gosh, I have serious concerns of abuse here by mom's boyfriend, again, it's just a stronger position where action is likely to be taken faster.
Right. Or changed behavior. If somebody's under a microscope,
yeah.
And that's a win, right? That's a win. Anything you can do to make your child's environment better is a win. And sometimes people get so caught up on proving what happened, they're failing to protect their child when they could. All right, we have 5 minutes left. So many questions. We won't be able to get to all of them. And I thank you all for being here and for your participation. This is a great question. Can you submit evidence that's been previously submitted? As an example, I submitted it in the divorce, but now can I submit the same evidence for modification of parenting time? It's police reports, etc.
Yes. You can if it's relevant to the issues in the modification. However, if this evidence was previously admitted into evidence, so this was, let's say you had an exhibit with 5 police reports with a summary page on top, and that was your exhibit 5 and you got it admitted, then technically it's already part of the court record. And you can reference it, ask the court to, oh, exhibit 5, I want the court to remember that and take notice. But if you have a lot of exhibits in your case, sometimes that can be tough. And so sometimes it's easier to just resubmit it and do it again. But do you have to resubmit it? No, you could reference the documents that had already been admitted. But again, sometimes it's just easier to resubmit it so it's right there and it's handy instead of having to go through the exhibit archives or something.
Yes, I agree with you. And sometimes judges will not allow, if you're going for a modification, sometimes judges will say, what's the changed circumstances since? Don't tell me what I've already heard that I already made decisions about. I'm not telling you that this won't get in, especially if it's police reports and we're talking about, let's say there's new allegations of child abuse. Your old stuff's probably going to get in as well to give credibility to the new stuff. But, if you're just looking for a do-over, you're doing them. So let's say previously during the divorce, you got 50-50 and you submitted these police reports and the judge still gave you 50-50. And now you want to do a modification. And the only thing you have is the old police reports that you already submitted. That is a harder case. And it's possible that wouldn't get in, or it's possible that the case would be dismissed because of a lack of change in circumstance. Lots of nuance.
Yeah, definitely.
Let's see. Military pensions. How do I go about getting it? I was awarded it, but how do I get it? And this is the case, not just for military pensions, but like you'll have a divorce decree that says, go divide the retirement accounts via Quadro. And then, 10 years later, it's not done. What can they do?
Talk to an attorney with experience with military benefits. It is complicated. There's a lot involved. That's great if you got the award, possibly, depending on what language was in the award. But yeah, I would, if you don't have the money right away, I would start setting some money aside for a consultation. And I would be looking for a Quadro attorney, a qualified domestic relations order attorney with military benefits experience.
Absolutely. And there are, the nice thing about Quadros and military divorce and things like that is this is federal law. It's not Arizona specific. You don't have to find a lawyer in your state. And there are places that do large volumes of Quadros and they're expert in it. So it's all they do. So you have some options there for sure. We are just out of time. Registration for Win Without Law School goes live on the 19th. Is that right?
Yep, sounds good.
Yeah. So on the 19th, you will be able to register for Win Without Law School. That is live courses with Julie and small groups. You're going to be able to get information and you're going to be able to practice. You're going to be able to talk about your case, present your evidence. It's going to be just awesome. Do you want to tell people there are different tracks for different courses? Julie, do you want to explain that?
Right. We've tried to cover each type of family law case that could come up. So on Mondays, we're going to focus on divorce. So whether you have a divorce with or without children, we're going to go from start to finish, from creating your case strategy to initiating your case to navigating the system to bring your case to a conclusion, be it through an agreement or through a contested trial. So that'll be Mondays. And then Tuesdays, we're going to talk about child custody establishments. So this is if you have one or more children together, you've never been married and you don't have any court papers in place, but you're wanting to get court papers for a schedule or for child support or for decision-making or, all of those things. So we'll talk about that on Tuesdays, how to create a case strategy, how to initiate your case or respond if you're the responding party, and then how to navigate your case to a conclusion through an agreement or through a contested trial. Wednesdays, we'll get into what we call post-decree. issues. So this is if you've already gotten divorced or you've already established child custody, but you need to change the terms of your parenting plan, or change child support, or change decision making, or change spousal maintenance. That would be a modification. And we'll also talk about enforcing terms of your divorce decree or your custody order. So Wednesdays is post-decree modifications and enforcements. And then Thursdays will be practicing trial skills. So if you're going to be going to a hearing on a temporary order or on a full trial, we're going to go through, how do you do an opening statement? How do you do direct examination? How do you get the exhibits admitted? Practice some of that stuff that Billy and I went through today. So it'll be Monday through Thursday for 10 weeks. Everything will be recorded. So if the time slots that were live don't work for you, you'll be able to access the recordings, and we'll have Q&A in conjunction with that. So it's a really comprehensive educational program to teach you all the things that you're not going to get by just filling out the court forms. The court forms are super helpful, and we're going to talk about those forms, but the forms alone are very confusing. So this is like a guide to how to use those forms effectively and when to use them and how to fill them out and all of that stuff.
It's going to be great. And I saw at least 2 people on my TikTok feed who said that they showed up in court and told their story and thought that would be enough, and it was a big disaster. And I'm sorry that happened to you, but hopefully we can prevent it from happening next time. Thank you, Brianna. Thank you, Julie. We'll talk to everybody soon.
Bye.
Bye.